on discussion.
Good morning. Please be seated. This is the time and date set for oral argument in cause number CV210419, Brock Family Partnership versus Tellurian Development Company. These proceedings are being video and audio recorded as well as live streamed. So we ask you to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes for their argument. Appellant's counsel is responsible for watching the clock to reserve a portion of that time should you desire. Also, we have read the briefs. We have discussed this case in conference. And at this point, counsel, if you're ready, you may proceed.
Thank you, Your Honors. We appreciate the opportunity to spend a few minutes with you this morning. I'm David Brooks. I represent the appellants, Brock Family Partnership and Brock Properties 2 LLC. With me behind the barrier is Brian Brock and Kirsten Lindell, who are some of the principals of the appellants. As we start our discussion this morning, Your Honors, I think it's important to remember the context of what brings us here. We'll spend the next 40 minutes talking about how the court is supposed to divine the intent of conflicting contractual clauses. And Mr. Harris and I will be debating those and hopefully providing the court with information the court needs to make its decision. But we are here on a motion to dismiss. And when the court applies the principles that apply to motions to dismiss, that applied in the trial court and that apply here, if there's a possibility that my clients are right, that paragraph 5 of the Second Amendment could be viewed as either ambiguous or as a modification of 6.4 or the other disclaimer clauses that appellees discuss, the trial court should be reversed. And the court...
Counsel, the problem I have is that the position doesn't seem very ambiguous to me.
Your Honor makes a good point. When you talk about the question of the language of 6.4, for example, and the language of paragraph 5, on their face, they're both pretty straightforward, right? What happens, though, is how you deal with the combination of those two clauses, especially when paragraph 5 is put into the Second Amendment at the end of this whole chain of agreements that go back from 2009 all the way to 2016.
But paragraph 5 amends section 7.1 of the agreement.
Yes, Your Honor.
And it begins with, the amended language begins with, without limiting the foregoing, meaning, as I read it anyway, without changing 6.4, without limiting all the other disclaimers that we've put in there.
One could view it that way, but
what's the alternate way? How could you view it any other way is the problem I'm having.
Okay, thank you, Your Honor. It's a good question. I think you may have noticed I filed a notice of supplemental authority this week. And in recital E of the development agreement, it points out that that agreement is subject to ARS 9-500.05 and is to be interpreted. That's one of the other interpretive principles we need to talk about, is that there's a statute that is in play here. And what you have is a situation that when you got to the time that the Second Amendment was inserted at a city council meeting, the city council wanted to make sure two things were going to happen. That these agreements would be consistent with the city's general plan, and that this provision, paragraph 5, would be retroactively put into all the agreements back to the development agreement, so that it would be clear that the city wanted to make sure that the developer took care of some safety issues. And that's what 9-500.05 authorizes the city to do, upon agreement of the owner of the property, as the court knows. So when you have those clauses, and you have this clause, paragraph 5, put into the agreement, you have to construe all of them together. And that is where I think
Right, and
the
if
rub
the
is.
city was suing to say, you haven't complied with our development plan or our agreement, maybe you've got a good argument. But how does the statute you cite, 9.500, alter or give a claimed third-party beneficiary right to sue under an agreement that specifically disclaims any right of a third-party beneficiary to sue?
I think in part you have to look at the language of paragraph 5 itself, Your Honor. And some language that we could easily overlook. It says Tellurian specifically acknowledges and agrees. So the parties were putting a special emphasis on that performance clause.
Right, and if the city were to sue, so be it. But how does this give your client the right to sue? That's the part that we're all hung up on. It's
Sure.
not whether they've complied with the agreement or whether they've complied with the statute instructing us on how to interpret the agreement, but specifically giving your client to be the ones to stand up here and say, hey, this agreement that we're not a part of, we can sue under it.
I don't think there's any debate here that the city could sue. But I also think that that's a red herring kind of an argument here. And the reason I say that is that the question is whether the third party who's not a party to the agreement also can sue.
Well, but Council 6.4 says, no term or provision of the Second Amendment is intended to be for the benefit of any person from blah, 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 and no other person from organization or corporation may have any right or cause of action hereunder. I mean, that seems pretty clear that if you're not a party to the agreement, this agreement isn't for the benefit of anyone else, and it doesn't give whoever that may be the right to sue.
Your Honor, when you apply the principles of contract interpretation, like the Corbin point that the court talked about in the United California case, and you have a specific clause, paragraph 5, put in at the end, the interpretive principle is that the specific could be viewed as a nullification or a modification of the general.
Except that the provision that you cite as the specific clause specifically says without limiting the foregoing, meaning we're not altering paragraph 6 and 5.4 and 6.4 before. How else can I read that?
Your Honor, I think, again, you have to go back to what the intent of this language is. And that's what we're trying to figure out, right, what the intent is. And when you have a specific clause inserted that imposes a performance requirement on Tellurian, you have to go back and figure out if it's ambiguous. I think if you look at the Beverly case and the Beverly case and the Aetna cases that we cited in the reply, they get to that question because there's competing clauses, right? And they say when there's...
That's the problem, is I just don't see the competition. I don't understand how... I don't see the amendment to 7.1 is changing anything in 6.4 or 5.4. And that's where you keep talking about competing clauses, but I'm like, 7.1 as amended says we're not changing the other two. So where's the competition?
Your Honor, I think you could get there if you say that the language in paragraph 5 is only for a third party that is not a direct beneficiary. And that's the question.
Yeah, if it didn't have that without limiting the foregoing at the beginning of it, I think you'd have a real slam dunk argument, or at least a very much stronger argument. But it says We're not changing everything that came before. And both of these provisions that your opponent cites came before.
They do, or the development agreement, the assumption agreement, the First Amendment, came before. But that's why you have to circle back, even with this, without limiting the foregoing. You still have to try to define the intent based on the documents as a whole.
Well, because you keep talking about defining the intent, and the first rule of statutory interpretation and contract interpretation is we look at the plain language of whatever we're looking at. And the language seems pretty plain to me. So how do we get beyond the plain language?
I think you have to look at it to see if, when you look at the two clauses together, and you have to define or look at the clauses and the contract as a whole, what does that do? And like I mentioned, in the Aetna case and the Beverly case, in both of those instances, and even in the Anwar case, which was a federal district court in New York, when you have these preclusive clauses, and you compare them to clauses that may yield a third-party beneficiary, that creates the ambiguity. And so then you have to go to the question, like in Taylor, and see if the proposition that we're advocating is reasonably susceptible of the language. And the court might say, well, it's not if you focus on without limiting the foregoing. I see what Your Honor is saying, but I think you can also say that it focuses on a specific instance, a single beneficiary who is a neighboring party, a neighboring property owner. And because of that, you have to look at the document as a whole and try to decide if it can yield a situation that should go beyond the motion to dismiss. And I think that's really what we're talking about. If it should go to discovery, if it should go to discovery, then the motion to dismiss should be reversed.
Can you address your 12J, since we've got a new provision in 12J? Can you address that argument?
Sure, Your Honor. The trial court recognized that the appellee failed to comply, but said my client didn't prove any prejudice. The issue, I think, becomes that the rule doesn't require us to prove prejudice. Now, I suspect the court could say, well, there's always discretionary power that the Superior Court has. That's true. But the Superior Court was trying to impose a burden that the rules on their face don't impose. And when the rules, both 12J and 7.1H, use the word must, that is mandatory language. And we mentioned the Adwell case, Your Honors, that talked about that use of that word in a 54C context.
What is the I found your argument to be very compelling, because we've interpreted must as being mandatory in other circumstances. So, but I'm hung up on what is the remedy? If the court had denied, said, sorry, you've denied this motion, it wouldn't be with prejudice. I mean, it's not like you can't file multiple 12B6 motions. So it would have denied it. They could have refiled with basically what they included in their reply, and we'd be right back at the same point. If we vacated the ruling now and sent it back for failure to comply with 7.1H, wouldn't that just have the court then reissue the motion to dismiss? It seems like we're elevating form over substance is my worry.
The rules of civil procedure have form.
Right.
That's why we have to live by them. And the rules don't identify the remedy, really. It's an unspoken result. But if you vacate it and you send it back, and we talk about another motion to dismiss, or maybe even we go through discovery and we're dealing with a motion for summary judgment.
And I realize that's for your main argument, but on this secondary point, if we were to vacate the granting of the motion to dismiss under this grounds, we would just send it back and then they could re-urge it. Wouldn't we be back here just 3 months later?
I think we would-
Unless the trial court had to change.
I think we would have another shot at the trial court, Your Honor. There would be a meet and confer, we'd see what that yielded, and perhaps there would be an amended complaint.
Do you put any weight on the fact that they did file in their reply that you had met and conferred? Do you put any weight on that subsequent remedial measure of type?
Is your question, did we file, is there anything in the record showing we had prejudice? Is that your question, Your Honor?
No. My question is, subsequent to you pointing it out to the court that their pleading lacked the certification, and they filed in their reply that we admit it lacked the certification, however, we avow to the court that we have met and conferred. Should that bear any consideration in your opinion?
No, because the meet and confer that they were talking about were various meetings that didn't have anything to do with the complaint that had been filed. It was discussions between the parties about the underlying substantive issue. And frankly, those discussions would probably end up being among the evidence about whether there was a breach of paragraph 5, if we get that far. But that wasn't in play for purposes of the motion to dismiss. I would like to reserve the remainder of my time.
Thank you,
Thank you,
counsel.
counsel.
Counsel, when you're ready.
Good morning, Your Honors. I'm Ralph Harris. I represent Tellurian. We're the appellee. Tellurian and the City of Tempe are parties to a development agreement focusing on the Rio Salado development project in Tempe. It's just south of the river, right where the 202 meet with the 101. If you know where that area is, sometimes it's useful to have a picture in your mind. It was once an elevated landfill, contaminated and high, and it was compacted down. A lot of geotechnical and environmental work, and there's now office buildings and hotels, and it's a very successful project. That's what we're here to talk about. The development agreement and related documents at issue were made with a municipality pursuant to the Slum Clearance and Redevelopment Act. Their intended purpose was to clean up and improve the Tellurian property to the city's satisfaction. Brock claims to be an intended third-party beneficiary relying on one sentence in one of the documents that does not require any specific performance, but only best efforts by Tellurian to include a circulation plan regarding adjacent properties. Brock is not named, and Brock's property is not identified in the contract. The contract talks about neighboring properties, but it does not specify Brock's. To the extent Brock's property might benefit from some circulation plan, Brock is at most an indirect beneficiary of one incidental item of a slum clearance rehabilitation project. I'm going to move, pretty quickly. I sense that there are certain things that I don't need to dwell down on too much. And if you have questions,
Don't take too much from the questioning I was asking your opposing counsel, because I don't understand what 7.1 or what the amendment to 7.1 would mean if it didn't impose some obligation upon you to work with neighboring council or neighboring property owners. So what is the purpose of this if it wasn't to impose that obligation upon your client?
so you have a clause added to the contract that allows the city to work with my client Tellurian to achieve the ends that they
No,
agree.
it doesn't obligate the city to work with. It obligates your client to work with other owners to include a circulation plan. So what is this just fluff and it doesn't mean anything? I mean, we interpret a language of a contract as having some significance, and there's an obligation imposed upon you, and it seems to be for the benefit of a third party. So how does that not at least get them past the motion to dismiss stage?
Okay, so you have a series of clauses that Your Honor has pointed out that provide no third-party beneficiaries. You have then this other best efforts clause.
Wait, what do you mean it provides no third-party beneficiaries? Other owners is, when you look at a property of land, or a parcel of land, and an agreement regarding other owners, that pretty easily identifies who the other people are that you're talking about.
So I'll be specific. In section 7.15 of the development agreement, the contract states, notwithstanding that the agreement is to be recorded, it is intended that no person is bound by or entitled to the burdens and benefits of this agreement unless such burdens are expressly assumed by or such benefits are expressly assigned to such persons. Then each of three subsequent documents clearly and expressly disclaimed third-party beneficiaries, including the assumption agreement, which had a clause in it that said, no term or provision of this agreement is intended to be for the benefit of any person, firm, organization, or corporation not a party hereto, and no other person, firm, organization, or corporation may have any right or cause of action hereunder. This was the first of two amendments, and then there's that was in the assumption agreement, and that same language was, as you know.
And then subsequently
Put into the First Amendment, the same language put into the First Amendment. I wanted to make sure we didn't lose sight of the fact of a small fact. There's a Second Amendment, and that's the amendment that Brock wants to point to. There's a disclaimer of third-party rights in the Second Amendment that's just a little bit different than the prior language that I just read. It was dickered, it was changed, so the parties didn't accidentally roll over into this new language. The Second Amendment says in section 6.4, no term or provision in this Second Amendment is intended to be for the benefit of any person, firm, organization, or corporation not a party hereto, and no other person, firm, organization, or corporation may have any right or cause of action hereunder. The point is that here we are, the very amendment to the development agreement that Brock wants to talk about has been slightly adjusted. The parties amended the disclaimer. So when I said that there's a disclaimer of third-party benefits, this is what I'm talking about. Each of these disclaimers is clear. They're not ambiguous. They mean what they say.
But so doesn't ambiguity not only come from the actual words used, but the whole context in it. If you read the language of 6.4 and 5.4, as Judge Morris noted, it makes the obligation to to work with the other owners meaningless, it seems to me. So you don't have to read all that together to figure out what that means.
So that's the point I was just getting to, and I think to address Judge Morris's comments and Judge Howell, your comments, here's my observation, and I think the court should adopt this. You have a series of disclaimers that are clear, unambiguous, and they mean what they say. No third-party beneficiaries. But then you also have this clause that says, well, Tellurian shall use its commercial best efforts to work with other owners to include a circulation plan for connectivity to benefit all parcels adjacent to the Tellurian properties. Section 7.1 was the cooperation clause with the city of Tempe. The clause that we're amending is pertaining to cooperation between the city of Phoenix and Tellurian. So what I'm saying is, I agree with the trial court when she said in order to construe the Second Amendment to provide the Brock's parties with third-party beneficiary status, the court would need to ignore Section 6.4 of the very same agreement. We submit that's a correct ruling, and the court should uphold that. My point is that you can enforce both agreements. You can enforce the series of no third-party claims, we'll call them, disclaimers, and you can enforce the clause of the good faith efforts. And who has the authority to enforce that clause? It's the parties to the contract. If the city of Tempe believes that there's lack of good faith, or if the cooperation is not there, the city of Tempe has the standing to bring that claim, and I suspect they will if they have a problem.
Well, but what if the owners come to that conclusion? Well, if they believe that Tellurian isn't using its best efforts?
Well, yes, Judge Howell, then the owners can go to the city of Tempe and raise their grievances. But the owners are not parties to this contract, and the contract says no third-party beneficiaries.
So the remedy is with the city of Tempe, not with the Superior Court.
That would be the case. The parties to this contract are the city of Tempe and Tellurian. They are parties to the development agreement as amended.
So when we look at that best efforts clause, why include it? I mean, to whose benefit is it? Just the city of Tempe? I mean, to include that much language in a contract and then disclaim it to anyone other than the intended or the contracting parties, did they even need to include it?
The city of Tempe wanted that clause and agreed to it, and so did Tellurian. You got to remember that this is a contract not to put in a road. This is a contract to remediate awful, lousy, contaminated, unstable land on the riverbed. And it took decades to get to this point. A whole lot of money was spent to remediate this land. Now, this is a miscellaneous point attached to a very substantial redevelopment project, and it's kind of the tail wagging the dog. Here we have a best efforts clause to participate with the neighbors, if you will, related properties, and they're not defined in the contract. It's an inconsequential, it's a miscellaneous provision of the overall contract. The neighbors are like the neighbors were in the case that we cited of Fort Lincoln, which the trial court found persuasive. There, it was a government contract, like this is. The neighbors said, we're supposed to be benefited by this agreement, and the redeveloper isn't doing what he's supposed to do, sued, and the trial court said, you know, this is a government contract, you guys are incidental beneficiaries. And the neighbors said, but no, wait, we are. We're the very people this was designed to help. We really are the beneficiaries. And the court said, well, okay, we'll assume that you are a beneficiary, and then went on to look at the fact that there was a exclusionary clause for third-party claims, and said, it's a government contract. It excludes third-party claims. I'm sorry. While I'm talking about the law, maybe I should mention one case. Counsel mentioned several cases. One of them was the Aetna case. Well, the Aetna case was based on Pennsylvania law. It's a court that found that there was a conflict in the language of 4 interrelated contracts. The court in Aetna said, there's 4 contracts, they're interrelated, I have to evaluate them all as one, and one of them said no third-party beneficiaries except for Aetna. 3 of them had different provisions, and they all had language that suggested that there should be third-party beneficiaries. The court said, I'm going to deny a motion to dismiss at that point. Fine. That's what Aetna said. What I want to bring to the court's attention is a case that we just found, affirmed by the Ninth Circuit in 2000.
Is it in your briefing, counsel?
Pardon?
Is it included in your briefing?
It is not. This is a
I
2020.
wouldn't waste time then with it. If you should we either file a notice of supplemental authority or include it in your brief?
Okay, very well then. But I will tell you that the Aetna case has been criticized, not adopted. The council also mentioned the Beverly case. Let's just mention a couple of these cases so that you could have a feel for what these cases are pertaining to. In Beverly, it is one of a couple of healthcare coverage, insurance coverage cases, where Blue Cross contracted with a hospital for reduced charges to its policyholders or members. That agreement prohibited the hospital from soliciting payments from members. The agreement had a third-party beneficiary clause containing 2 sentences. The first sentence says there were to be no third-party beneficiaries, and the very next sentence says, notwithstanding the first sentence, members' rights to benefits under that agreement was not affected by the first sentence. And that is at Beverly 429 South SC 508 and 839 Southeast 2nd at 471, where the court says, notwithstanding the preceding sentence, nothing in this section shall affect a member's right to receive coverage services pursuant to the terms of the agreement. So no third-party beneficiaries except the members, because this is a contract set up for the benefit of the members. The hospital submitted a statement to Mrs. Beverly for medical services, and the issue was whether Mrs. Beverly, who was a Blue Cross member, could sue for the health insurance benefits she'd purchased. The court, of course, held that the agreement specifically allowed for Mrs. Beverly to make a claim, and it allowed her to proceed. Mrs. Beverly's case doesn't support the Brock's position. In our case, there's no exception or carve-out stating no third-party beneficiaries except for Brock, or any other carve-out, or any other thing. The exceptions are clear, blanket, and absolute.
Counsel, if you, just to make sure we've covered it, and you can use your argument however, your time remaining, however you want, but can you address their argument regarding 7.1H and the failure to provide the required certification?
It was a new rule, talked about 12J.
Yeah.
It was a new rule. I hadn't focused on it. I apologized to the court. I explained we had attempted to work with counsel before to resolve this, to no avail.
But as counsel pointed out, it is not just the dispute at large. It is supposed to be specific to the complaint. And I think his point may be well taken, and that your reply, although talking about we've had negotiations and any further negotiations be futile, didn't really specify that these were after the complaint was filed, which is the purpose of the rules, to kind of force people to go and say, hey, let's talk before we try and resolve these cases,
right,
or dismiss these cases. Well,
clearly there was no prejudice because there was no requested amendment, as pointed out by the court. The parties are still in disagreement in every respect on this.
But isn't that the case before the adoption of this rule? I mean, this addition had to serve some purpose, don't you think?
Yes, and if I had seen the rule and had been focused on it, I would have brought it to the attention of counsel and complied with it. We felt like we did what we could. We didn't make the required certification. We did after the fact, explaining to the court. The court seemed to accept our apologies and said, we understand. It looks like it was a futile situation.
So if we back this out and we don't look at it in the context of this case, but we look at the adoption of that rule and that language in a vacuum, what do you think the must contained in that rule change?
Well, part of what was going on here is that rule was changed.
20 days old.
Yeah.
It's 20 days old, I get it. So this is the first time we've seen it.
Yeah, and to be honest, I apologize to you and I apologize to them for not being aware of the rule in advance, but I think this case is a little bit different than going down the road.
Let's not talk about this case.
Couldn't you?
In the event that somebody fails to comply with the must include the certification kind of language, what would the remedy for that be?
I think the opposing party might raise that with the trial court, and the trial court would have discretion to decide, I'm going to either disallow the motion or bring the parties before the court and find out, is there something that we can do? I would think if I were a trial judge, and I'm not, but if I were a trial judge, I would bring the parties to a conference, either on the motion at issue or a status conference, and say, can we get this resolved? Which is what normally happens in my cases. The trial judges are pretty good about gathering the parties and getting to the bottom of an issue like that so that we don't waste a lot of time and so forth.
Shouldn't the trial, again, talking in the vacuum of not this specific case, shouldn't the trial court have denied your motion without prejudice and let you refile it? I'm sorry, I said your motion. Denied a motion filed without a certification,
Yeah.
without prejudice, and refile it.
Well, I suppose the court could have done that in this case. If that had been the case, then we would have redone the motion, done the certification, and would have complied. But they didn't, and I think now significant prejudice would occur to all the parties if we undo this and send it back. So to answer your question, I think what should the court do? Gather the parties and make a ruling and get to the bottom of it. What could the court do? I think the court has some discretion to gather the parties and resolve the matter, and it should do that. I don't know if that's about the best I can tell you. What else am I going to say? I didn't see the rule. It was, 5 days, 20 days, whatever it was. I missed the rule. It was futile. They're not agreeing to our motion. They never did. We've had a series. I understand your point that this was a little bit of a different conversation, but we had been talking with them for a long time, and they weren't agreeing with us. I think that's where we are. So let me just skip to my conclusion then. I was going to talk about the cases a lot because there are some differences, but here we have a development agreement with its related documents. It's a contract for remediation and development of blighted land. The Second Amendment, calling for best efforts, was not the primary purpose of this contract. The possibility that Tellurian's best efforts might result in a traffic circulation plan, which might be included in the project, which was most an incidental aspect of the project. Any benefit Brock might expect from a possible circulation plan is indirect. Brock is an indirect beneficiary.
Counsel, your time is run.
Okay, thank you.
Thank you. Counsel.
Thank you, Your Honors. I have two main things I want to go back to. Judge Morris's question about without limiting the foregoing in paragraph 5. If you look at it, remember, it says section 7.1 of the development parcel agreement is hereby amended to add the following last sentence. And then it goes to the sentence that we've been discussing. And it goes to the without limiting the foregoing. So what does that refer to? It refers to the prior sentence in 7.1. And the prior sentence in 7.1, if you look at it, it's on APP 30 in the record. It says, the city and developer hereby acknowledge and agree that they shall cooperate in good faith with each other and use its commercial best efforts to pursue the economic development of the property as contemplated by this agreement. Unless another standard is specified in this agreement, all consents and approvals provided for in this agreement shall not be unreasonably denied, considered, or delayed. That's what it's referring to. We're not changing or limiting that first sentence. But what we are doing is adding another obligation, a performance obligation that imposes requirements on Tellurian. So I think, Your Honor, if you were perceiving that, or if your question was focused on does that refer to all the other agreements and all the disclaimer clauses, I think the answer is no.
The other 6.4, which was also amended in that Second Amendment, say no term or provision of this Second Amendment. So
that's exactly where I was going next, Your Honor. I think when it says, when counsel mentioned no term or provision in the Second Amendment, and then you put it into the development agreement, and you populate it through the development agreement, the assumption agreement, and all the amendments, all of a sudden you've created ambiguity. Because you say, we're not changing anything, any of the terms in the Second Amendment, but paragraph 5 puts it all the way back into the development agreement. And so if they say we're not providing for in the Second Amendment, well, what does it do when you consider everything else? And I think that's where you can go back to the issue I raised with the statute, 9-500.05. Two provisions. It's supposed to be consistent with the general plan, and we didn't put the general plan in the record, but if you can look at paragraph 15 of our complaint, Your Honors, the facts that are alleged are consistent with the general plan, which focuses on cross-access agreements and shared driveways, and safety. Because why do we need to open up a driveway? So my clients who are adjacent can access a private road that is available to the public because of the increase in traffic that is going to happen on Rio Salado.
Councilor,
And
I
that's-
want you to take a minute to address why your remedy does not lie with the city of Tempe.
I'm sorry, Your Honor.
I'd like you to address why the remedy you're seeking does not lie with the city of Tempe as suggested by opposing counsel.
Because it focuses on a specific party, non-party, who is to be benefited. And it's the adjacent property owners. Now, yeah, the city of Tempe could pursue that. We talked about that before. But when you have a clause that meets all the requirements of a third-party beneficiary, even though another party to the contract can sue, doesn't mean that you don't satisfy the requirements for a third-party beneficiary. I think that's why we're here, Your Honor. Overall, at the end of the day, I think the briefing leads us to a fact issue. I think it leads us to a question of what the parties actually intended. There's a dispute in the cases. Some say that the disclaimer clauses apply pretty much on their face. Some say, no, that creates exceptions or ambiguities that trigger a situation where a motion to dismiss isn't the appropriate remedy. Some even said they would reverse a summary judgment on those principles.
Counsel,
Thank
your
you.
time is run.
We would urge the court to vacate the judgment. Thank you.
We thank you both for your arguments here today. We will take this matter under advisement and issue a written ruling in due course.
Thank you, Your Honors.